So this is chapter 2 for our employment law course, and we'll be looking at provincially regulated employers. Something I did not emphasize in our chapter 1 was the distinction of provincially regulated employers and federally regulated employers. Even though this distinction is in the lecture slides, I did not emphasize this, and I will do so now. So the way I like to explain this distinction is looking first at the federally regulated employers, because an employer will be federally regulated if their main business activities are of a national interest. So, for example, banking, transportation, uh, could be national transportation or interprovincial transportation companies such as airlines, national road or um, railroad transportation, uh, banking, as I said, Canada Post. So those are federally regulated employers. They are regulated. The main source, not the only, but the main source of legislation for provincially regulated employers will be the Canada Labor Code. And they form about 10% of employees in Canada. And the majority of employees, so almost 90% of employees in Canada, they are provincially regulated. So provincially regulated employees or even employers are those in which their business activities are not of national interest. So most companies, even though they have, we're talking about national chains such as franchising, let's say Home Depot, Walmart, or um, Tim Hortons. Even though those companies are present everywhere in Canada, or mostly everywhere in Canada, their main business activities are not of federal interest. They are more related to the provinces. They are more delivering services or products with a local or regional objectives. So 90% of employees in Canada will be provincially regulated. And this will be the main focus of this course. So we'll be mostly dealing with provincially regulated employers and employee, whereas we will, um, have one chapter on federally regulated employers and employees, because they, again, are just 10% of employees in the country. We'll talk about holidays in the future, but just to give you an example here, um, Family Day, which is a provincial holiday only, not a federal one. So during Family Day, banks are open. Canada Post is doing their deliveries because those are activities that are federally regulated. So they follow holidays on a federal level, not on a provincial level. But we'll be discussing holidays on both federal and provincial levels in the future. So, distinction made. Let's check what the objectives for this chapter will be. And we'll be touching upon issues related to the hiring process, also using executive search firms, and then how to best perform background checks in a way to be legally compliant or to be performing under the best practices. And then we'll end this chapter by looking at the distinction between an independent contractor and an employee. So, for an individual employment contract, or when we look at the individual employment law, an individual here is being, I'm telling you, individual as opposed to a collective, because collective agreement or a collective relationship is related to unionized workplaces, which we'll be looking at in chapter 3, the next one. So when I say individual here, I mean an individual employment relationship. So employer and an employee, okay, as opposed to a collective. So here we need to look at common law, because as we saw in chapter 1, common law or case law or the precedents, they are one of the sources for employment relationships, for employment law. And we also need to look at provincial legislation, provincial employment related legislation. And those will be mostly based on statutes or acts and regulations. So remember, we call them a legislation. And the legislation, the employment-related legislation, will mostly set the minimum rights and the minimum mechanisms for enforcements. And when we say here minimum, we're saying that employers and employees, they may agree on something more, on something bigger, on something else, but they cannot agree on whatever is below the minimum. And the best example here is the minimum wage. So you can negotiate a minimum, a wage, hourly wage for $20, for $50, for $100, but not below the minimum wage, because the minimum wage is set by the legislation, more specifically by the Employment Standards Act. Okay, so again, legislation, employment-related legislation, they will mostly deal with the minimum rights, minimum enforcement mechanisms. But the more employers and employee agree, the better it will be. It may be for both parties. And legislation, even though we're talking about provincially regulated ones, legislation may be of provincial nature or federal nature. And an example here is, so the Employment Standards Act is a provincial act. However, all provincially regulated employers, they have to comply with employment insurance legislation and also Canada pension plan legislation. And those two are of federal nature. So keep in mind that even though we're talking about provincially regulated employers, both provincial and federal legislation may apply to the relationship. So what are some areas in common law that may pose some liability, some responsibility, some legal responsibility to employers or to employees? So first one is misrepresentation by candidates. So when candidates issue a false statement, or it could be the wrongful hiring by the employer or by the executive firm while using headhunters in terms of negligent misrepresentation. We also have inducement, which means that there are aggressive recruiting practices in a way to force, between quotation, force an employee to change jobs. We also need to look at restrictive covenants, and those are clauses or sections that prevent employees and even former employees to compete or to disclose information or even to solicit on clients, on suppliers, and even employees. We also need to look at anticipatory breach of contract. So the contract was formed, however, one of the parties decide to not follow with the deal, decide to try canceling the deal before. And we also have the background checking issues, and this will be related to negligent hiring as well. So we'll look into details, and inducing breach of contract, where in most cases employers, again, try forcing the employee or their prospective employee to breach their current contract and change jobs, or even breach uh, their non-competition clause, or their confidentiality clause. So we'll be looking at all of this in details from now on. First one, so misrepresentation by job candidates. Um, so if you lie in your resume, or if you lie during your job interview, and let me use myself as an example. So I told you, or I may have told you, I'm not a lawyer in Canada yet, but I'm a lawyer in Brazil. So I'm using this as an example to say, if I have my resume here in Canada and I call myself a lawyer, just a lawyer, it will be regarded, implicitly regarded, that I am a Canadian licensed lawyer. So I would be lying. I would be misrepresenting. I need to call myself either a foreign lawyer or Brazilian licensed lawyer, but I cannot call myself only lawyer. And if this misrepresentation, this false statement, seriously prejudice the employer. So imagine an employer is hiring me because I'm a lawyer. I can practice law. I can work on litigations. I can give legal advice. Or if the misrepresentation makes the relationship not trustworthy, then the misrepresentation may be a cause for dismissal, just cause for dismissal. So this is very serious, and I like to warn students, do not misrepresent while being interviewed or in your resume, because this may be just cause for dismissal. And with just cause for dismissal, we'll learn this by the end of the course. You have almost no rights, and you can be dismissed right away. And this is a negative incidence for your career, or this may be a negative incidence for your career. So again, I use myself as an example. Other examples would be qualifications. So you represent you have some training, some type of education, or some specific work experience. And if they would be directly related to your job role and responsibilities, or if by finding out what you claimed is not true and it causes the relationship to be not trustworthy, then just cause may be there. However, if you have minor misstatements, minor false statements, even deliberate ones, even intentional ones, but those that do not induce the employer to hire you. For example, previous salary. So you're negotiating a salary for your new job, and the prospective employer asks what your current salary is, or your former salary was, and you increase it by some dollars, or even more. So those are regarded as minor statements and would not justify just cause for dismissal. Okay? And if you are working for the company, if you are an HR employee, you are trying to act in the best interest of the company. So here, a good practice, if you are in this role, is to use in the job application form, or mostly form, this clause. It is called an attestation clause. So the clause will read something like this: information provided is true and complete. False statement may disqualify the applicant or may be a just cause for dismissal. So by using this attestation clause in the job application form for example, if you come to find out there was a misrepresentation by that candidate, you made the candidate aware that this could disqualify the candidate, or if the candidate were hired, would also justify just cause for dismissal. So I would call this as a good practice if you are working for the best interest of the company. If you are in HR position, you would want to use a clause similar to this one. Okay, in a way um, to have best practices working for your employer and for your position and role as well. When we look at misrepresentation with regards to hiring, so now we look at the other side. Here we were talking about the candidate, when the candidate is misrepresenting experiences or qualifications, etc. But now we are talking about misrepresentation by the employer. So when the employer misrepresents, could be the salary, could be details of the position, could be anything related to the job the applicant is applying for. And the prospective or the employer here may be liable, legal responsible for damages for the job applicant. So the legal case here, or the precedent we need to look at, is Quinn versus Cognos. And here, this case actually was about an accountant position. So the applicant applied for this position, got an interview. The applicant was currently working, but then decided to apply for this job and got an interview. And the company here said the job was associated with a big project, even though the project had to be yet to secure funding. So the candidate got the job, moved to Ottawa, and then 18 months later, the candidate or the employee was terminated, was dismissed. So the employee sued for negligent misrepresentation and won the case. So what this precedent teaches us is that when parties know what is happening, when they have a special relationship, so here the company knew what the project was about, they had to secure funding, they knew the job candidate had a secure job at that moment and was willing to move family, move provinces, etc. Then also on the top of it, the innocent part will makes a statement that is not true, that is misleading, and also when they did not take any reasonable care to verify whether the information was accurate or not, and when in this case the employee relied on that information to make a decision. So everything that was told to the employee that led the employee to change jobs and move again to Ottawa. And if the employee or the innocent party in this case suffers negative consequences, events, or is faced with damages, then misrepresentation is established. So again, what this case law or this precedent teaches us is that if you are an HR employee, be very careful, not only you, but the whole HR team, be very careful on what you are telling to prospective employees, to applicants, to job applicants, because if they rely on those on this information, and then this information becomes a lie or a false statement, that will become or will be the main reason for a negative event, negative result to the hired employee. Your company may face lawsuits based on misrepresentation. And here, negligent misrepresentation means that the false statement was not made intentionally, but was made out of care, with not being careful, not being cautious about disclosing that information. So even if you, HR employee, honestly believes that information to be true, because you work for the company, you have all the information related to the position, you have the obligation to check whether that information is true, is accurate or not. Because even if you believed it was true, but you didn't check as you should, it may be regarded as negligent misrepresentation. Moving forward, we also have fraudulent misrepresentation. So the main distinction here is related to fraudulent, because we are still talking about misrepresentation. We are still talking about a false statement. So whereas negligent misrepresentation is a misrepresentation that was believed to be true, turns out not to be, there was lack of care. In fraudulent misrepresentation, there is intention. The person issuing that false statement knows the statement is not true. So the HR, the interviewer, the job interviewer, lies about the salary, lies about the roles or responsibilities, lies about reporting, who the candidate or the applicant will report to. And then the applicant suffers damages because of such a lie. It's not sufficient, it's not enough, the occurrence of a misrepresentation. There also has to be a result, a damage to the employee or to the applicant. And in this case, again, the misrepresentation is related to an intentional false statement. Okay, so that's the main difference. But it's still misrepresentation, and it still attracts liability. In other words, legal responsibility to the employer. So best practice, if you are an HR professional, make sure you have accurate and complete information. Make sure all interviewers, if there's more than one, know the job, know the description, know what the package will be, the offer will be, etc. And also, it's good, it's a very good practice, and we'll see more throughout the course, to have a written employment agreement. And you could have specifically a clause, we'll see in a minute, that all previous oral representations are void. So you have a clause in the written agreement, and this is one way to try correcting mistakes during the hiring process. When you use a search firm, and we're still talking about misrepresentations, you should be aware that the employer is still liable for any breaches or any misrepresentations or inducements that take place. Because the search firm is actually acting on behalf of the employer. So one way to reduce such liability or such exposure, first of all, you should have a careful selection of the firm. So look at their reviews and experience, etc. You should also set boundaries and guidelines for them to provide their services. So what they can say, what they should not say, etc. And from a specific legal nature, you should also, or you could also, if you can negotiate this, have the executive or the search firm to provide you with an indemnity. An indemnity, it is a provision or could be a contract in which, in this case, the executive search firm would uh, put themselves in the obligation to cover any damages uh, the employer may suffer that is related, that may arise from the services of the executive search firm. So the employee in the future could uh, sue the employer because of misrepresentations or breaches or inducements, as I said, but because that employee was hired using the executive search firm and the indemnity clause is there, it means that the employer would pay any compensations they had to. However, they could turn back to the executive search firm and say, hey, you have to compensate this to me because this arose out of your services to us. Okay, so but some executive search firms, they will not accept this. So this is more on a bargaining power. If you employer has this bargaining power, you can demand or you can have this indemnity clause in the contract. Looking now at inducement. So inducement, also known as allurement or enticement, it is when there are aggressive recruiting techniques or even inflated promises that will lure the employee to a new job. So you're offering more than a regular employer would offer, just or with the main intention uh, to hire that employee. And they have to be really exaggerated. So let me give you an example. I have a contract with BCAT. Well, I'm hired in a collective agreement because we are unionized. Um, but let's say another educational institution wants me to work for them. I say I don't want, thanks. And then they make me a better offer than what they originally did. And I again say, no, thanks, I'm not interested. But then they offer me double. They offer me double vacation, double salary, paid 2 week vacation with my family in Central America resort at a beach, etc. So they are being very, very aggressive, and they are also promising a lot to me because their main intention is to take me out of BCAT. So in case I accept this job, um, my new employer may be sued by BCAT or may be sued by myself if I have damages because I was hired under an inducement or under aggressive recruiting techniques. Um, I'm not saying you cannot offer uh, better conditions for prospective employees. Yes, you can, but make sure to offer longer notice of termination if you do so, because the employee relied on those better terms, and you cannot just dismiss the employee after 1 month or even after 1 year in a so short period. So the employee is actually relying on those better terms. Okay? So you got to be cautious about being aggressive. And I understand, and we should understand that it's fair, it is okay to try to get the best candidate possible, and that best candidate, that best employee or professional may be currently working for another company, but uh, keep in mind that you may be, or the company you're working for may be acting related to an inducement in an inducement way or inducing the employee. So you may attract more liability to your company. So now we look at restrictive covenants. Those are restrictions. So either current employees or former employees may be restricted, may be barred from some actions. And this is those restrictive covenants are highly used nowadays. Because nowadays there's a lot of IT, not only IT, but we're talking about technology. All types of technology could be soft technology, hard technology. So this technology, they have to be protected, and employers are investing a lot of money on them. Uh, so they want to protect those. They do not want employees to go work for their competitors. They don't want their former employees to attract current employees to come with them to a new company, and they also do not want former employees or even current ones to be disclosing confidential information. So those are legitimate interests of employers because they are investing on those. However, those restrictions uh, have some boundaries. They have to be limited, and we'll look at some details now. First of all, if you are having a restrictive covenant, a non-competition clause, a non-solicitation clause, or a confidentiality clause, or all of them, they have to be an express term in the employment agreement. So it cannot be implicit. It cannot be an implied term. It has to be expressed. It has to be written out in the employment agreement. And again, it will prevent the employee and also former employee, because those clauses usually last for 1-2 years after the employee left the company. And this is totally legal. So examples, as I said, confidentiality, not disclosing confidential information you had access to. And here would involve technology, but could also involve customers list, suppliers list, everything that the employer or the former employer was investing to have to create. Could also be financial methods, marketing methods, etc. Non-competition. So usually the employee cannot work for a competing company or employer, or cannot start their own business in competition with the former employer. And non-solicitation of clients and employees. So the former employee cannot solicit, cannot invite clients, even suppliers or former employees to come and join them in their new company or in company they are formed. So here we have we have to balance those three interests. The employee interest, which is their right to use the knowledge, skill, experiences for new jobs, because so I've been working for BCAT for 10 years, and now I want to go to another educational institution. So everything I acquired while working for BCAT, knowledge, experience, expertise, I have a legitimate interest to bring all those with me. So this is one interest. We also have the employer's interest, that is to protect their business, their technology, their confidential information, everything they invested on. And we have the public interest, which is Canada is a democratic society, and also there has to be free competition. So companies, they have the right to compete freely in the market, whereas employees also have the freedom to change jobs and work for other companies, etc. So courts will usually try to balance all those three interests: the public one, the employees one, and the employer. And how do those work? So all restrictive covenants, they cannot be a restraint of trade. So they cannot have the intention to prohibit trade. So no, I don't want uh, any other company to start this business. I don't want my employees to work any of my competitors, and there may be several. So this is not legal. This is not valid. So such a restriction will be void. On the company's position, for those restrictive covenants to be valid, to be legal, you have to be actually protecting a proprietary interest, an interest that is worthy of protection that you have created. So it has to be firm specific, company specific, not general expertise and skills. The most important here fact here is that the restriction has to be reasonable in terms of duration and geographic location. So the restriction can only exist where there's competition for the employer's product or service, and only as long as it takes the employer to recover. So a general rule, but it's just a general rule. It will vary on a case-by-case basis. General rule will be 2 years. 2 years and within Lower Mainland. But let me say, let me exemplify. So I'm working for a pet shop. So there are pet shops in almost every neighborhood. So I cannot restrict someone to work in a different pet shop, even within a city, because there are many pet shops. And usually if I use one pet shop and I like the employee that provides the services to me in my neighborhood, I will not change pet shop to a different city or if it's too far away. So what I'm trying to convey here and to exemplify here is that restrictions in terms of both geographic location and time, they have to be really, really reasonable. And it will vary based on a position, based on the interest of the employer. So again, for a pet shop, let's take an example of a pet groomer. I would be able to restrict within the region, within the neighborhood. So you cannot work for another pet shop in the same neighborhood, let's say Central Burnaby, and let's say for 6 months. Because in 6 months, I would be able to replace that pet groomer and try to keep my current clients as the pet shop owner. But not more than this. Whereas there may be positions, scientists, researchers that may allow the employer to restrict in a more wider area, let's say Lower Mainland or south of BC, and also for 1 year, let's say 2 years. But this will always vary based on the position and the legitimate interests of the employer. Okay? And the third aspect is that it cannot be contrary to public interest. In other words, it cannot be overly broad or restrictive. So a good example here is a clause that says, for example, the employee is under confidentiality restrictions, non-competition, and non-solicitation for any other companies whatsoever during 5, 10 years or 20 years, or as long as the company is in business. So this is overly broad and restrictive. This would always be a void, illegal clause. Okay, so those are important clauses, and the burden of proof, the onus, or the one who has to prove the clause is legal, the restrictions are legal, is the employer, because it is usually the employer who drafts the clause. So the employer is the one responsible to prove it is a valid clause. It is reasonable in terms of time and geographic location. It is actually protecting their firm specific interests, and also it's not overly broad and restrictive. And any doubts in the clause, in the restrictions, they will always be resolved in favor of the employee. okay? Because usually the employer has a greater bargaining power than the employee. One thing that is very, very, very important here, if you are an HR employee, so let's say the company did their job, they hired a lawyer, they got legal advice, they have valid restrictive covenant in all the company's employment agreements. However, an employee is wrongfully dismissed. When employees are wrongfully dismissed, and we will learn about wrongful dismissal in the future, the valid restrictive covenant becomes inapplicable. The valid restrictive covenant does not bind the employee anymore. So the employee is not bound by that anymore. So the example here is, again, valid restrictive covenant, but the employee was dismissed by their manager, by their supervisor, who got mad for specific situation and wrongfully dismissed the employee without giving notice or uh, um, committing any other faults or illegalities with the employee. Imagine such a scientist or research. The next day, the next week, they could go to your competitor because their once valid restrictive covenant is not applicable anymore, is not binding on the employee anymore. So you gotta be very cautious about this. Now let's look at anticipatory breach of contract. So it is here the situation is the contract is formed already. So the employee was hired, contract was signed, parties are in agreement. But then one of the parties, could be the employer or the employee, decide to break the employment agreement before employment begins. So start date will be Monday, January 18th, and Wednesday, January 13th, either the employer or the employee informs the other they are not starting employment. They don't want the job anymore, or they don't want to offer the job anymore. So when there's a break, when there's repudiation, legally called, in an employment agreement before employment begins, this is known as anticipatory breach. And because the contract was formed already, employment legislation already applies. So it means that if there's no cause, just cause for either dismissal or resignation, either party has to provide notice, minimum notice. Could be the 1 week notice minimum, or in some events 2 week notice, or if the agreement says 30 days, it should be 30 days. So a notice is required in anticipatory breach of contract. Parties cannot just call one another or email one another saying, hey, plans changed, job is not available anymore, or plans changed, I don't want the job anymore. If they do this, they may be sued for wrongful dismissal or wrongful resignation. We'll talk about wrongful dismissal and resignation in the future, but for now, just keep in mind that once the contracting form is formed, even though employment has not started yet, if the contract is broken, then regular procedures for either dismissal or resignation must apply. An exception is if there's frustration in the relationship. And frustration here is not the feeling of being sad or not happy. Frustration here is a legal term. Frustration here is not what you are feeling now, for example, by watching this pre-recorded lecture. Frustration is a legal concept that says something happened that was out of the control of the parties, and now obligations of the contract cannot be fulfilled. So the employee was hired to work at a warehouse, but before employment started, the warehouse caught fire. Doesn't exist anymore. So the agreement is frustrated. No parties had a responsibility on that. The fire took place out of the party's control. Or another way around, the employee would be a driver, an unfortunate situation happens, and the employee gets hospitalized, or the employee gets disabled either temporarily or permanently, so the employee cannot drive anymore. It means the contract is frustrated because performance cannot happen anymore. In this case, then anticipatory breach does not apply. Okay, but that's an exception. Now let's look at background checks. So background checks are may be related to negligent hiring. So hiring in a way that was not cautious, was not careful, and may cause the employer, may attract liability, legal responsibility to the employer. So background checks, they are usually related to employment references, educational or professional credentials, credit, but credit should only be performed if the position requires money handling. Why would you get credit check for a, let's say, no, not bar server, for, let's say, someone working as a gardener, for example? Why? If you go on a credit check and the position does not require money handling, you may be sued for damages on this. Police records. So there are also background checks for police records. And the law says that it is possible to refuse a job for someone with a criminal record, but not in BC. So the criminal record in BC or Yukon and Quebec, they have to be related to the job duties. So if you're hiring someone to be a security guard, then a police record would be okay. Or eventually to be a school bus driver, etc. So keep that in mind. In BC, Yukon, and Quebec, a criminal or police record check only if the job duties are related to knowing or are related to any issues the applicant may have incurred in the past. And there's also background checks with internet and social media. And here, companies, they should be cautious because they may fall into this mistaken identity. They may look at one person's profile, but it may be the case that it is not the real person, or it's not the applicant. It is someone with the same name or any other issues. So you have to be cautious. Also, this could arise, or this could bring liability with regards to discrimination. So you're checking Facebook account of a potential employee of an applicant, and you come to learn the applicant's gender or religious affiliations or any other movements they are involved with, and you don't like it, you don't want it in your company, this may bring you a liability with regards to discrimination. So you got to be very cautious with those. So how do companies should do this? How should companies conduct background checks? Well, first of all, they have to notify the applicant, and the applicant has to give their written authorization. Well, actually, I'm saying here written authorization, but could be verbal. However, verbal is difficult to prove in court. So I highly recommend it to be written so that you can keep proper record of the authorization to perform the background check. The information that you collect while performing the background check, They should be kept confidential. Why are you sharing this within the company, with other employees, with other departments, if they are not needed? Criticism, negative references, they are okay, they are allowed. However, they have to be true. And if you are in doubt, do not use them. Or even if you are giving a reference related to a former employee, be cautious about criticizing or give negative reference as or in case it is not true, because you may be attracting liability as well. Just make sure it is true. And the best thing here, the best practice would be to run those background checks only after a conditional offer of employment. And what does this mean? Well, it means you had, let's say you had 100 applicants. You have chosen one, the best candidate. But you don't want to hire the applicant until you run the background checks. So what you do is you make a job offer. However, in that job offer, you say that it is conditional on a successful background check. So you're actually offering the job to the candidate, but you may withdraw the offer, and this withdrawal will be legal in case the background check is not successful. So that is a conditional offer. And one benefit here is that you save money because you don't need to run background checks on a lot of people. You have already chosen your best candidate. And also, you are avoiding here, you are not avoiding 100%, but you are actually reducing the risk here of any alleged discriminations related to other candidates. So other candidates would say, oh, because of my gender, because of my religious affiliation, because of my ethnic origin, or other grounds, I was not hired. Okay? So an example would be like this. In the job offer, you could have a paragraph similar to this. If you're the successful applicant, we'll be making a conditional offer contingent upon your passing a criminal record check. So in this case, the criminal record check is related to the job duties. And at the time of the offer, you will need to consent to the criminal record check. Once you get clearance, you'll be confirmed. So you could use this actually not in the job offer, but in the job posting. And then all applicants are aware that if they get a job offer, that job offer will be conditional and conditional upon a criminal record check. So you're making it clear, very clear, that that check will be made, and you are certainly reducing, not to say avoiding completely, allegations of discrimination based on positive criminal records. All right, so now the last topic is related to the distinction between employee versus independent contractor. And here the importance is mostly related to benefits of the parties. What I mean here is, if you are an independent contractor, you don't have taxes withheld in your pay stub. You get the full amount. However, you don't get the protection of the minimum standards, workers' compensation. You are not getting CPP, you're not getting EI. And the employer, they are actually saving money because they are not paying employment taxes. They are not contributing to EI, to CPP either. So there's a growing trend, towards independent contractors. Because of this, both parties may see advantages, but courts and governmental agencies do not like this at all. because this is usually fraud. This is usually not the real situation. And what the real situation uh, is what will count for the courts, for governmental agencies. So for CRA, for example, CRA is interested in learning um, what the real situation is, regardless if you are hired as an independent contractor, but you are in the company um, from 8 to 5 or from 9 to 4:30. If you're actually working as an employee as opposed to an independent contractor, they will fine you because taxes are not being withheld. You're not contributing to EI, CPP, etc. Okay? So that's the issue that involves this distinction. And again, um, courts and governments, they want to know what the real situation is. And they have developed mechanisms to find it out. So that's what we are going to see. And if you are an employee, you are actually protected by the Employment Standards Act. You are protected by minimum wage. You are required to you are entitled to a notice to be dismissed. You are also protected by human rights legislation, occupational and health, uh, occupational health and safety legislation as well. So, what are independent contractors? Independent contractors are the truly self-employed, independently employed workers, and they are engaged actually in specific work. An example here, I have a garden in my house, and I hire a gardener to do the garden work every 2 months, to say so. So I don't hire a gardener to be my employee. I hire a gardener as an independent contractor, as a company, to run a specific work in my house that will last 1 hour, 2 hours, 5 hours, one day, every month, every 2 months, every 6 months. So this is the truly independent contractor. It could also be the case you started your own company, but the company is still small and you don't need to hire an accountant. So you hire an accountant firm to do the accountant job for you. So you send them your invoices, your fiscal documents, but they are not your employees. Or the accountant themselves is not your employee. They just perform specific job to you because you're still small. You don't need and you cannot afford a full-time accountant in your company. So they are not employees of the business. They just perform specific job, service to you. And some advantages, as I said, to be for the employer of an independent contractor is that the employer will have no statutory remittances. The independent contractor not entitled to the employment standards protections, as I said, and there will be no wrongful dismissal, no common law wrongful dismissal because they are independent contractors. They are just performing a service. If the service is not of the quality you want anymore, you just say, I don't want anymore. And for the independent contractor, advantages are tax breaks. So as I said, no withholding of taxes, and there's a more flexibility to work for others. So the garden, for example, may work for myself and for a lot of my neighbors. An accountant or an accountant firm, but an accountant as an independent contractor may provide their accountant services for several companies. So those are some advantages for both the employer and the independent contractor themselves. But as I said, courts and governmental agencies, they want to know what the real situation is. So they have developed those tests with regards to the relationship. They have developed the control test, risk test, organization test, and ownership test. So in most cases, people are hired as independent contractors, but in real life, they are employees. And why are they employees? Why do we know they are employees? Because they do not pass the control test. Because if they were truly independent contractors, they would control their own job. They would control when they would work, where they would work. Like the gardener. If the gardener doesn't want to work for a year, they don't work. But if you are an employee, if you are a gardener of a golf club as an employee, then you know when you have to work Monday to Friday or on the weekends from 9 to 4, etc. And where you have to go, etc. So if you, as an independent contractor, you have to pass the control test. Also the risk test. Who makes the financial investment? Or who bears the loss? So the gardener, if the gardener has their lawn machine broken, they have to fix it. They have to buy another one. I don't. But as a golf club, I would have to buy a new lawn machine for my gardener who is an employee. So this is the risk test. The organization test. So is the person actually, are the services provided by the person an integral part of the company, an integral part of the business, or just ancillary to the business? So again, for my house, gardener, just ancillary to my house. So just every month, every 2 months. But for a golf club, for example, could be on a regular basis. The accountant, example, the same thing. An ownership test. Who owns the tools? So similar to the risk test, who owns the gardening tools? For the golf club itself. But for the independent contractor as a gardener, it is the gardener. They own the tools. When they come to my house, they bring their own tools and they do the work. So this way, if you are a truly independent contractor, you have to pass all those tests. If you fail in any or all of them, you are an employee. And if you are hired as an independent contractor, but you are an employee, CRA will fine the employer, will also fine the employee because taxes were not withheld. There will be issues with CPP, with EI. So make sure if you are an employee, and I know sometimes we need the job. However, the employer, we are successful in the job application, we get a job offer, but when you see the contract says independent contractor, service contract agreement. So I know this. I know this in real life. Here in Canada, in Vancouver, in BC, I've seen this already. Companies, they offer a job, they make a job posting, but then when they bring the contract to be signed, they send the contract, it is providing services. But they give you a laptop, they tell you to come at your schedule, the location of your job, etc. So this is a real fraud. And I know sometimes the applicant needs the job, needs the money, so they end up accepting. But keep in mind that both the employer and the employee may suffer regulatory penalties, mostly fines. Okay, so that's very important. And if you are an HR employee, make sure all employees in the company, they are actually higher than employees. And if the company really wants to hire an independent contractor, make sure you run all those tests: the control test, risk test, organization test, and ownership test, so that the company is hiring a true independent contractor. Okay, they are free to perform their job where they want, when they want, as long as they comply with the quality requirements you have set for this service relationship. Okay, so that's a very important issue. So here are some steps to minimize the risk of an independent contractor, a true independent contractor, to be deemed an employee. So the contract, highly recommended to be a written one, no statutory deductions, no. You should have an indemnity clause. Remember the indemnity clause I told you with regards to the executive search firm in the beginning of the lecture? So if the company has to pay any damages that arose out of the independent contractor services, it is the independent contractor service who should be liable, not the company. But this only applies if you have an indemnity clause. You should allow the independent contractor to work for others. You should avoid setting hours. The independent contractor can work off-site because they are independent. They can accept or refuse work. So they may say, no, I'm not available now. Or the gardener may say, hey, Joel, this month I'm not available. Sorry, but I can refer you or can recommend you another one. You should also have the independent contractor to have their own insurance, commercial liability insurance, no performance review, because the person is an independent contractor uh, rather than an employee. They could be incorporated. They could be a company. I'm saying here should incorporate. No, not necessarily. They could be. It's better if you are contracting with a company, so it helps you more, making it a truly independent contractor relationship. But they could also be not incorporated. It is fine. And you should also minimize their integration into the organization. Okay, so not make the independent contractor real part of the company. Remember, their services are ancillary to the company, not the main part of the business. All right, and I told you that was the last subject, but we have one more here that is related to employment agencies, and this is actually very important. So using temporary employment agencies, in other words, it is leasing personnel to a company. I'm not sure you have studied at BCAT before, but an example at BCAT is that janitors, cleaning personnel, and also security personnel, they are not BCAT's employees. They come from agencies. So this is an example of using employment agencies. And um, who is liable? Is the employer liable? Is the employment agency liable? So those are aspects we need to consider here. A few aspects I will consider here with you. So what really counts to the courts is who the ultimate source of remuneration is. So at the end of the day, where do the funds come from to pay for those employees? So not only those who signs the check, but where do the main source of money comes from? So, for example, a security company that has several clients and provides their security guards, security services to other companies and people, they are actually a true uh, payer, or they are actually the ultimate source of remuneration. Whereas if an agency, employment agency, is a small one and they only rely on one client, so chances are this is more likely a situation in which the employer itself would be liable rather than the employment agency. Other factors that are important is who has daily control, who exercises the daily control. So in BCAT's example, is BCAT setting the daily schedule of the security guards, or it is the employment agency based on BCAT's instructions to the employment agency? So this is another factor. And who hires, who disciplines, and who dismisses? So if you are in a position in the company where your employer hires employment agencies for specific job duties, make sure you do not exercise daily control towards the employees themselves, but you can do this via the employment agency. So you call the employment agency, or you email them, or you tell them you need security guards from 9 to 9 during your shop hours. So you tell the employment agency, they will tell their employees who will come, what their shifts will be, when they will turn shifts, breaks, etc. Okay, and they will be the ones hiring. They will be the ones disciplining. So if there's something that happened in your store related to those employees, you should communicate, you should report to the employment agency. You should not directly try to discipline that employee or even try to dismiss. Because in this, if you do this, you are more attracting a relationship of employer-employee rather than employer and employment agency. Okay? And some types of employees, this is maybe you should know this already, but just to make it very clear, in general terms, there's no formal distinction based on between employees based on hours, but there are some categories that are used, and those categories are full-time or part-time. So full-time is anything more than 30 hours per week. Part-time, less than 30 hours. Some companies define it differently, but if you define it differently in the contract, then whatever the definition of the contract is applicable, as long as it is not below the minimum standards. So you cannot say that more than 30 hours is part-time. No, you cannot say this. But you can say, for example, in your company, 26 hours is full-time, is considered full-time. So whenever it is for the benefit of the employee, you can change this. And then temporary will be a contract that can be for a full-time or part-time position, but in which the time is defined, is specific. It's not indefinite period. It is a specific period. So our part-time studies here at BCAT, faculty, they are hired under temporary contract. They are called contract positions because they are just hired for the time of the course. So like this case, January 5th until March 31st, if I'm not mistaken. So this is a temporary contract, specific contract. Casual work is the type of work that it is casual. And because it is casual, the employee may refuse, may decline, may say, no, I'm not available. And also, because it is casual, the employee is not entitled to termination notice or termination pay. And the agency, as I just explained, is the relationship between the agency and the agency employee, not the employer and the employee, because the employer actually has a service agreement with the agency. And it is the agency that has an employment agreement with their employees. And the main service of the agency is to lease personnel to an employer, as I have just explained. So an agency agreement is, or a type of an agency employment relationship is the one that is between the agency and their own employees, even though their employees work for the agency's clients, not for the agency itself. All right, so that's the end of chapter 2. And in chapter 3, we're going to look at unionized workplaces. Thank you.